Court calls case People versus Carlos Mack.
People. Rob Brown appearing on behalf of Mr. Mack, Your Honor.
Before we even get into the individual cases, pause here. This opening stretch tells you exactly what kind of docket Judge Simpson is dealing with today. This isn't one dramatic trial. This is rapid-fire justice. Case after case, defendants cycling in, attorneys juggling files, and the court moving at a pace that leaves very little room for mistakes. Carlos Mack's name being called isn't about guilt or innocence yet. It's about procedure, timing, and control. And that matters more than most people realize. Courtrooms like this run on structure. Miss a date, misunderstand a condition, or speak out of turn, and the consequences can snowball fast. You'll notice immediately how Judge Simpson sets the tone. Direct, clipped, efficient. No theatrics. That's intentional. When a judge runs a docket like this, it signals authority and keeps things from spiraling. But here's the hook. When things move this fast, defendants sometimes forget where they are. They talk when they shouldn't. They volunteer information. They reveal more than their lawyer wants them to. And as we'll see today, that can change everything in seconds. So as this session unfolds, pay attention to who understands the system and who clearly doesn't. Because in this courtroom, knowing when to stay quiet can matter just as much as what you say.
Your name?
Carlos Mack.
All right, what are we doing?
Requesting adjournment, Your Honor.
February 4th, 2026, 9 a.m. bound continued.
I'll give you my
Court calls case People versus Joseph Griffin.
All right, so on behalf of the township, good morning.
Good morning.
Nice snowy morning.
I don't know about nice. Snowy morning.
Ron Brown appearing on behalf of Mr. Griffin, Your Honor.
Your name?
Joseph Bertrand Griffin, Your Honor.
Thank you.
Your Honor, we're requesting an adjournment of this case. February 4th.
February 4th, 2026, 9 a.m. bound continued.
Can he still get released to treatment?
If it's in the file, he can get released. I don't
Did you talk to Wayne
think to be
County?
questioned about that. If the
Well, I
order's
haven't-
there, the order's there.
But I called him.
Is this person in Zoom?
Yes.
When I'm done.
The court does call the case People versus Walter Peterson.
Good morning, Your Honor. Robert Ellman on behalf of Mr. Peterson, who I believe is present over Zoom.
Yes, he is. Mr. Peterson, can you state your name?
Walter K. Peterson.
25.
Thank you.
That's the one.
All right, what are we doing on this?
Your Honor, I've been newly appointed on this matter. I haven't received discovery yet, so I'd just be requesting an adjournment.
All right. Okay, Mr. Peterson, I'm gonna put your case out a couple of weeks so your new attorney can come talk to you.
Sir, is this the one about Myers?
Mr. Peterson, I'm going to advise you to not make any statements right now as we're on the record.
Cause they don't
So I'll
adjourn
come
it
talk-
about 3 times.
Hold up,
Mr. Peterson,
Mr. Peterson, no, this is not about Meyer.
Okay.
Thank you. February 4th, 2026, 9 a.m. Bond continued.
thank you
At
very
least
much.
as
Your
I
Honor.
can tell, it's not about Meyer.
Have a good day.
You do the same. Court calls the case People versus Marcus Jackson.
Eli Goldstein appearing on behalf of the defendant. Is this the one where I stole the stuff from Myers?
Your name, sir?
I'm Marcus Jackson.
Thank you. All right, what are we doing?
Your Honor, this case was reauthorized as a felony, so I'm moving to dismiss this case.
All right.
I'm obviously not going to object, Your Honor.
This is a dramatic procedural twist that flies past most viewers if you're not paying attention. A case being reauthorized as a felony means it's no longer properly before this court in its current form. And that's why Judge Simpson dismisses it. Not because the defendant is cleared, but because jurisdiction and charging authority matter. Here's where people get confused. Dismissed doesn't always mean you're free forever. It can mean this isn't the right place for this right now. The prosecution can, and often will, refile. Still, in this moment, it's a win, a real one. You can hear it in the defense's response. No objection. Of course not. So ask yourself, if you were sitting there, would you understand what just happened? Or would you walk out thinking the case vanished completely? This is why legal clarity matters, and why commentary like this exists.
Case is dismissed on Alley Cross. All right, thank you. In Zoom. Court does call the case Kimberly sued, People versus Kimberly Sue Douglas.
Morning, Your Honor. Raymond Cook for the people.
Ron Brown appearing on behalf of Ms. Douglas. She's in custody or was.
Yes. Doug, you're trying to get somebody to unmute you, I know.
I'm sorry.
There they go. All right. State your name, please.
Kimberly Sue Douglas.
Thank you. All right, what are we doing on these?
Request adjournment.
During the matter to February 4th, 2026, 9 a.m. Both cases. Bond will continue. All right, thank you, Ms. Douglas.
Thank you.
Court calls case People versus Nicholas Meath.
Morning, Your Honor. Raymond Cook for the people.
Assistant Public Defender Natalie Pate with and on behalf of Nicholas Meath, who stands to my right. Please state your name for the record, sir.
Nicholas Smith.
Thank you, Your Honor. I believe this case is still set for final settlement conference on February 6th, and it is my understanding we are here today for a bond violation. And it is my further understanding that the basis of the bond violation being that my client did pick up a new case. As to that, he is in front of Your Honor for a probable cause conference tomorrow. He does admit to the bond violation as to there being a new case. We are not going to be speaking as to the underlying contact, but we do admit that there is that new case. And there was that police contact. We are also asking if the court would allow us to briefly make a bond motion when appropriate.
So you just want this to continue to final settlement conference
Yes, Your Honor. Thank you.
and jury selection. So we'll continue to those dates which have been previously set. He admits to the violation.
This segment with Nicholas Meath is one of the most important instructional moments on the entire docket. He admits the bond violation. That's huge. An admission takes discretion away from argument and places it squarely in the judge's hands. Judge Simpson now isn't deciding if there was a violation, he's deciding what to do about it. Listen closely to the defense's strategy. They don't argue the underlying conduct. They pivot to mitigation, education, employment, family support, future compliance. This is textbook defense lawyering, and Judge Simpson responds exactly how experienced judges do. Skepticism first, conditional openness second. 30 days, credit for time served, and the possibility of reduction if proof of schooling is provided. That's leverage. The court is saying, show me responsibility, yeah, and I'll consider mercy. If you're watching this and thinking school or work doesn't matter in court, it absolutely does. So here's the question. Should prior good behavior outweigh a new violation? Or once bond is broken, should consequences be automatic?
You want to argue bond?
Very briefly, if the court would allow it.
They still have to sentence him on the violation.
Yes, Your Honor.
Okay, go ahead.
Your Honor, my client is asking if the court would consider, after sentencing a bond violation, of course, if you would consider reinstating his PR bond in this case. He's being held on a $1,000 10% bond on his felony case, to my understanding. He is a student at Eastern Michigan University. He has 5 classes left to complete his degree. He advises me that he lives by himself in an apartment in Ypsilanti, Michigan, and he has part-time work with his father, he advises, who is a chiropractor. My client does receptionist work for him. He's really eager to hopefully post on the other case and be released in order to continue his classes. He does understand the importance of returning to court and getting back into compliance with bond.
All right. Well, is he still enrolled?
To my understanding, yes, and his father has, to my understanding, paid the tuition. Yes, Your Honor.
Well, maybe I'll consider something else if you do that. But what I'm going to do is I'm going to deny any request to change his violation or change his bond at this point. But I will sentence the defendant to 30 days. I'm going to give him credit for 21 days. I will consider further reducing that if you get the information regarding schooling.
Thank you, Your Honor.
All right. Thank you.
Thanks, Your Honor.
Court calls the case of the People versus Emilio Vasquez. Is it Orellana? Yeah.
Morning, Your Honor. Raymond Cook for the people.
And Assistant Public Defender Natalie Pate with and on behalf of Mr. Vasquez Orellana, who appears via Zoom.
My
So you
double L's.
your name for the court.
Emilio Vasquez Oriana.
That's it. It's already on. I mean, I can see it and I still want to do the L and never mind. All right. What are we doing?
Thank you, Your Honor.
Happens all
I
the
have been
time.
able to I have been able to discuss with my client at this time. We're asking to set this her final settlement conference, please.
All right. Jury final settlement conference will be set February 6, 2026, 9 a.m. Jury selection, February 9th, 2026 at 8:30. Those are in-person proceedings. Bond will continue. Court calls case People versus Timothy Welch.
Just Conrad Siller on behalf of Dismissal Township.
Ron Brown appearing on behalf of Mr. Wells. Think we have worked something
Your
out.
name, sir?
Timothy Wells.
Thank you.
We have worked out an agreement, Your Honor. Mr. Welch is going to responsibility to an added count of double parking, given the age of the case. He's also, it's not part of the plea agreement with this court, but he is going to make restitution to the officer in charge within 60 days of his release.
Got it.
But that is not part of
Part of the, got it. Is that a correct statement?
Yes, Your Honor. 49.99, is it, Mr. Silver?
correct.
60 days from when they cut you.
All right. Sir, do you admit responsibility to the fact that on November 15, 2011, at location on Carpenter Road, that you double parked the motor vehicle?
Yes, sir.
All right, court will accept that admission to count two. Count one is dismissed. Fines and costs of $180. That will be due 90 days after release.
So that's 150 you owe. Well, 140. You know the math. Yeah.
All right, thank you.
Thank you.
Is that it for you guys? Oh. Court calls the case, People versus Kayla Walden.
Assistant Public Defender Natalie Pate on behalf of Ms. Walden, who appears via Zoom. Ma'am, can you state your name for the court?
Kayla Walden.
Thank you, Your Honor. I just received some documents from my client yesterday that I just provided to the people yesterday for them to review and for their consideration. I would request an adjournment.
February 4th, 9 a.m.
Thank you, Your Honor.
Thank you, ma'am. Court calls the case, People versus Tanisha Akins.
Conrad Siller on behalf of Dismissal Township.
An Assistant Public Defender Natalie Pate on behalf of Ms. Akins, who appears via Zoom. Ma'am, can you please unmute and state your name for the court?
Tanisha Akins.
Thank you, Your Honor. This is a license case, and I'm respectfully requesting a lengthy adjournment. Ms. Akins states to me that she recently filed for Chapter 7, and she did provide me some documentation that she has been meeting with her attorney as recently as 2 days ago. Long story short, she believes the hold on her license may be lifted within the next couple months, and she may be eligible at that time. So she is making progress, at least on that end, but she is not eligible for a license at this time.
I guess I don't get what the bankruptcy has to do with the.
This exchange is a masterclass in judicial clarification. Judge Simpson isn't dismissing the bankruptcy argument. He's interrogating it. Bankruptcy doesn't magically erase criminal or licensing consequences. It can affect civil judgments, fines, and enforcement, but only in specific ways. Watch how the judge walks the logic step by step until it clicks. Once he understands that a civil judgment may be causing the license hold, everything shifts. Suddenly, resolution becomes possible. Dismiss the misdemeanor, handle the parking offense, avoid enforcement issues during bankruptcy. That's judicial problem solving in real time. And notice something else. The judge protects the defendant from future complications by not setting a payment date. That's foresight, that's experience. So think about this. Should courts be more flexible when someone is actively trying to clean up their financial life? Or should legal obligations stay rigid no matter the circumstance?
I believe there's a civil judgment that has currently a hold on her
Got it.
license.
Okay, so it's because of the civil judgment and then looking to potentially discharge that judgment. Right, got it.
In that case, does she want to admit double parking today to resolve it?
Oh, I believe she would. Ms. Akins, given the situation, the prosecutor is willing to dismiss the misdemeanor today and let you do the double parking ticket today if you would like to do that now.
Oh, yes, that's fine.
So, Your Honor, I move to add count two double parking. If you accept that admission, move to dismiss for the charge.
Okay, Ms. Akins, do you
Yes.
admit responsibility to the fact that on where's the date and location? On the date of August 30th, 2025, location of Ellsworth Road in Pittsfield Township, Washtenaw County, State of Michigan, that you double parked the motor vehicle?
Yes.
All right. Court will accept that admission to count two. Count one is dismissed. Although we haven't received notice of a bankruptcy stay, I'm going to assess fines and cost of $180. I'm not going to give a pay date so we don't get into any issues of trying to enforce payment of money with somebody in bankruptcy.
Understood, Your Honor.
All right. Thank you.
Okay,
Ms.
thank you so
Akins.
much. Thank you.
Court calls case People versus Clarence Benson.
Under the silver on behalf of Pittsfield Township.
Ron Brown appearing on behalf of Clarence Benson.
I'm Clarence Benson.
Thank you. What are we doing?
Requesting adjournment, Your Honor.
During the matter, February 4th, 2026, 9 a.m. Bond continue.
Thank you.
Court calls case People versus Jacob Simmons.
Bring the cook for the people.
What's your name, sir?
Jacob Simmons.
Mr. Simmons, you are before the court on a misdemeanor citation, or not a misdemeanor citation, a misdemeanor complaint that alleges that on or about October 9th, 2025, at the location of Washtenaw Avenue near Golf Site in Pittsfield Township, Washtenaw County, State of Michigan, that you failed to stop an ID at a personal injury accident. You understand the nature of that charge, sir?
Yes, Your Honor.
That's a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. You understand the maximum penalty, sir?
Yes, Your Honor.
All right. First question I have for you is, do you want to be represented by an attorney?
Yes, Your Honor.
All right. It's a public defender case.
Ron Brown appearing on behalf of Ms. Simmons, waive reading, stand mute, request adjourn pre-trial to obtain discovery.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pre-trial in this matter will be adjourned to February 4th, 2026, 9 a.m. Defendant's bond will be set at $5,000 personal recognizance bond. All other standard conditions, including no assault behavior or possession of any weapons or ammunition or anything fashioned to be a weapon. There's also to be no use of any alcohol, recreational marijuana, or any illegal drug. Do you understand all of that, sir?
Yes, Your Honor.
All right. And I don't have any of that information regarding that. I'll just leave it. All right. Thank you. Court calls case of the People versus Nicola Bill.
Bring the cook for the people.
Arraignment. No. It's an order for cause. Bill, not checked in. Bench warrant will issue for defendant's failure to appear.
This is the harshest moment so far, and it comes down to one thing: absence. Failure to appear is one of the fastest ways to turn a manageable case into a serious problem. No debate, no mitigation, no explanation on the record. The warrant issues immediately. A $5,000 bond with a 10% provision might sound procedural, but it represents real consequences: arrest, detention, stress, and expense. Judge Simpson doesn't hesitate, because hesitation here would undermine the court's authority. This is the cautionary tale of the docket. You can have a minor case, you can have options, but if you don't show up, the system moves on without you, and it moves against you. So ask yourself, should courts offer more grace for non-appearance, or does strict enforcement keep the system functioning?
Bond will be set in the amount of $5,000. I'll give a 10% privilege on that. That warrant will issue immediately. Calls the case of the People versus Alexis Alexander.
Under the silver on behalf of Pittsfield Township.
1907. Okay, got it.
Ron Brown appearing on behalf of Ms. Alexander.
Okay.
Your Honor,
So, go ahead. Okay, so first thing is, Miss Alexander, and I don't know if this is encompassed in the agreement, has another case, a state case, that she has a warrant on.
That's not part of the agreement. We need to arraign on that one.
All right. Okay, then on the, she also has another warrant. And another warrant. And another warrant. And another warrant.
Trying to take care of all of,
What?
trying to take care of all of this.
I got 5 warrants in a new case. You're not doing a very good job.
This exchange with Alexis Alexander is where Judge Simpson's frustration finally surfaces, and it's earned. Multiple warrants across multiple courts signal more than oversight. They signal systemic noncompliance. When a judge lists warrant after warrant, that's not theatrics, that's a warning. Courts coordinate more than people realize, and unresolved matters don't stay isolated. They stack, they compound, and they eventually collide in moments like this. But notice what happens next. Despite clear irritation, the judge doesn't default to incarceration. He pauses, sorts jurisdiction from township matters, and begins untangling the mess one strand at a time. That's the balance judges are constantly forced to strike. Accountability without collapse. The defense does exactly what—
But, okay, I'll deal with these in a minute.
In the township.
Yes.
And come to double parking, she has provided proof of. Parking and sure.
That's what you want to do, right?
Yes.
She will accept responsibility to double parking.
And Miss Alexander, do you make responsibility to the fact that on November 10th, 2025, Carpenter Road, Pittsfield Township, Washington County, State of Michigan, that you double parked motor vehicles?
Yes.
Court will accept that admission. 2 count. 2 count. 1 is dismissed. Fines and cost of $180. When can you pay that?
Your Honor, can she get 60 days to pay?
Pay it by March 31st,
Okay. Thank you.
2026. All right, that's that. Then we've got a warrant that's out of my court. He hasn't been arraigned. Jeez, Pete's everywhere. On mine.
Correct.
All right. It's here. Got it. Okay. So I'll cancel the warrant on that case. As to the, do you want to be represented? It's a retail fraud secondary. You want to be represented by a public defender?
Yes.
Public defender case.
Ron brought a pring on behalf of Ms. Alexander. Your Honor, can I have the case number?
Yes, case number is 251-1452.
Waive reading of the charges, stand mute and request adjournment so I can get the police report.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea to that charge. Bond in this case will be set $5,000, personal recognizance bond. I'll order standard conditions, no assault to be, including no assault behavior or possession of any weapons. You understand that, ma'am?
Yes, sir.
And there should be no possession or consumption of any alcohol, recreational marijuana, or any illegal drug. In that case, also, I will indicate that you are not to go to any Target store
Okay.
in the state of Michigan. You understand that?
Yes, Your Honor.
This condition surprises a lot of viewers, but it's actually very strategic. A no-entry order tied to the alleged conduct isn't about punishment, it's about prevention. Retail fraud cases often include location bans to remove opportunity. Judge Simpson is narrowing risk, not escalating force. What's more interesting is how calmly it's delivered. No lecture, no moralizing, just clear boundaries. And Alexis Alexander acknowledges them without resistance, which matters. Compliance in tone often influences future discretion more than people expect. This also highlights how bond conditions can shape daily life. These aren't abstract rules. They affect where you shop, who you see, what you do. So consider this. Are restrictions like this fair safeguards, or do they edge too close to pre-conviction punishment?
That takes care of that. Now, then you have 4 warrants out of 14A2
Yes.
before Judge Barr. I think on all of these, the public defender is already the attorney of record.
Ron Brown appearing on behalf of Ms. Alexander in all 4 cases. First, ask that the warrants be recalled.
So, do we have a pretrial date over there? It won't. All right, what I'll do is I'm going to cancel the warrants. Grant a personal recognizance, $5,000 bond on each of these cases. They're all driving while license suspended. So I'll do that. I'll cancel the warrant on all of them. Bond is 5,000, and then I'll give a pretrial date. All right, so on case ending in 1936, February 3rd, 2026, at what time? 8:30. At 8:30 a.m. Set that for a pretrial. There we go.
14A2. Okay.
Then the other 3 are the same.
Yes, sir. It's January 28th.
Okay, so on those, I'll cancel your warrants.
Thank you.
Give you a personal recognizance, $5,000 bond. Set you for January. Pretrial will be set for January 28th, 2026 at 8:30.
All right. Thank you.
Thank you.
One more thing, I don't know if the court has, I did see another warrant out of the 15th district court. I don't know if this court would have that file.
I would not.
Okay. She has one out of 15, like sort of another retail fraud.
So you need to go over, if you're gonna try to clear everything up, you need to go over
Hold
to
on, everything for me.
15th District Court.
Yes, Your Honor.
And
Yes. Oh, yes, that's on it.
All right, don't forget to show up for these.
I won't, Your Honor.
Because normally on a warrant, I take you into custody, but I'm gonna trust that you're gonna get there, whatever.
This might be the most consequential discretionary moment of the session. Judge Simpson openly states the default outcome, custody, and then chooses trust instead. That's rare, and it's risky. The judge is effectively saying, "You've given me every reason not to trust you, but I'm going to anyway." That kind of discretion cuts both ways. If the defendant appears as ordered, it validates the decision. If not, the consequences will be harsher next time. Courts remember when trust is broken after being extended. Listen closely to the final instruction. Don't forget to show up. Simple words, enormous weight. This is the last window before consequences become unavoidable. So here's the engagement question. Should judges continue offering trust after repeated failures? Or is there a point where discretion must end?
Thank you.
All right. All right. Thank you.
You have a great day. Thank you.
You too.
This courtroom session under Judge Simpson shows the justice system in its most practical form. No grand speeches, no theatrics, just decisions, each one carrying real consequences. We saw how bond violations lead to jail time, how procedural errors can dismiss cases without resolving them, how warrants escalate quickly, and how judicial discretion can still open doors when accountability is shown. From Carlos Mack to Alexis Alexander, the pattern is clear. Courts reward compliance and punish absence. They listen to mitigation but demand proof. And once patience is exhausted, the system moves decisively. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.